Hello to all our listeners and welcome again to our Raro and Company Roundtable podcast series. My name is Jonathan Kisia, an associate in the Dispute Resolution Practice Group. With me today, I have Sandra Kavagi, a senior associate at the firm, working with the Dispute Resolution team in the Employment and Labor Relations Practice Group. Additionally, with me today in this discussion, I am joined by Erastus Rabut, an associate in the Employment and Labor Relations Practice. This is the second episode of our four-part series for the International Labor Month. In the first part, we discussed issues surrounding working from home, remote working, flexi hours, and data privacy concerns arising around these working from home arrangements, more especially for employers. In today's episode, we are delving into the minimum wage order guidelines and the intricacies surrounding collective bargaining agreements, popularly known as CBAs, in the private and public sector. Please listen in, and we trust that you will pick something of interest and or value at the conclusion of this discussion. So diving right into today's discussion, maybe for historical context or background, what would you say is the genesis of the concept of minimum wage and the legal framework behind it?
Thank you so much, Jonathan, for that question. My understanding of what the minimum wage order is and what its intention is that naturally in the society we have those individuals who we can say are either skilled or do not have the necessary bargaining power to negotiate for their wages as compared to that person who has the requisite education that would help them in negotiating their wage. So that they are protected, we have in Kenya enacted the Labor Institutions Act, which establishes the minimum wage orders that take care of those kind of persons in the society. And a classical example would be that house that you have in the house. Probably the person comes, they do not have any purpose. You just need a nanny to take care of your child. You do not need any specific qualification to employ that person. And naturally, there would be an inclination on the part of the employer to push for as low a salary to pay that particular individual as is possible. But then the law comes in and tells you that for this particular employee, the minimum salary you can pay them is this much, so that they are protected owing to their low bargaining power for one reason or the other.
If I'm getting you correct, what you're saying really is it ties to the powers that they have. Those of us who have sleep power maybe fall under the minimum wage order, and those of us who are in skilled labor, which is a discussion we'll have later, fall under the bracket of the CBAs.
Indeed, that's actually very true. What I would loosely say is that this act takes care of the power imbalance in the employment sector between the skilled and the unskilled. It is all about protecting that person with no formal education or no proper bargaining power against those who have the financial muscle, who is the employer.
Okay, let me throw it over to Sandra, maybe to discuss the Labor Institutions Act in more detail.
Thank you very much, Jonathan. Thank you, Erastus. I think you have put it perfectly on the basis for or the genesis of the minimum wage order. So I will just dive into where now the minimum wage order, the minimum wage guidelines find a footing in law. And Erastus has mentioned it. It is under the Labor Institutions Act, which is Chapter 234 of our laws of Kenya. And the Labor Institutions Act is an act of parliament that establishes labor institutions in Kenya, and it provides for the function, powers, and duties of those institutions. Now, of specific reference to the topic that we are speaking today, we look into there's the establishment of the Wages Council under the Labor Institutions Act. And for those of us who had an opportunity to listen in on the International Labor Day celebrations in Kenya on the 1st of May, you could have had the President of the Republic of Kenya, speak on this. And more particularly, Jonathan, you will recall that the president had directed the cabinet secretary in charge of labor in this country and to consult with the wages councils and all other parties relevant, like unions, for example, to try and come up with a workable minimum wage for Kenyans. Now, these wages councils established under the Labour Institutions Act are sector specific. Now, when I say that the wages councils are sector specific, I generally just mean that the councils are established depending on the different sectors of work that we have in Kenya. For example, there is the wages council for the agricultural sector. There is a wages council for tailoring and garment making, and just petrol stations and so on, just by way of example. Now, they are sector specific, and this is also captured within the Labour Institutions Act for the reason that the members who will sit in those particular wages councils, at the best, they are persons who have the relevant experience within the specific field, and therefore they would then be the best people to investigate on the needs within the specific sector, and then thereafter advise the Cabinet Secretary of Government on what the needs are and what remuneration, for example, would be best serve that sector. And that's why then one of the functions of the wages council, according to the Labour Institutions Act, is investigation of the remuneration that is currently existing under that sector, and then the conditions of employment also affecting that sector, and then advising the ministry on the changes that can be made to on the remuneration or the working conditions of the employees working under, for example, the agricultural sector. Now, this brings us to the point that the functions of the Wages Council, as captured in the Labour Institutions Act, and which you, listening to me, you may now have been able to follow, is that they then investigate the remuneration that is applicable in the sector at the time when they are conducting the investigations. They also look at the conditions of employment that exist within that specific sector at the time that they're looking into these investigations. And then with the information that they gather at this investigation level, they are then able to advise the Cabinet Secretary of Labour or the government on the extent of increase of remuneration or the conditions of work that they need to be implemented in that sector. So this is the connection that the President of Kenya was establishing when he made his speech in the International Labour Day celebrations as regards to minimum wages. So what we are saying is that the minimum wages order or the remuneration provided for under the minimum wages order constitutes the minimum terms of conditions of employment. So an employer is expected to apply the, for example, remuneration under that order at the level prescribed, basically as the minimum, or at a higher level. And Jonathan, you seem like you have something to add on this.
Yes, I think what I just found particularly important to highlight was failure by an employer to adhere with the terms of the minimum wage order do attract a penal offense. So I think it would be prudent to highlight, at least for our listeners, that this issue of minimum wage is very serious. Indeed, is even being litigated in our courts.
Yes, Jonathan, just riding on the back of that statement, your employee, that gardener or that house help, if you end up paying them below the minimum wage order or what is stipulated under the minimum wage order, you run a risk of your employee filing a claim against you before the Employment and Labor Relations Court for underpayment or salaries as stipulated under the law. So aside from the penal consequence attached to non-adherence with the wage order, there is also the risk of a civil claim in the nature of an employment case being filed against you as an employer for paying your staff below the minimum wage order.
Okay, thank you, Erastus. And maybe to move on forward, what are some of these basic minimum terms of conditions of employment as per the minimum wage order?
A minimum wage order, aside from just stipulating the minimum wage, it somewhat, to some extent, codifies the salient features of what would be found in a normal employment contract. One of the salient features of an employment contract would be a provision for house allowance. The wages order also requires of an employer to either provide housing, or if they don't provide housing for that particular member of staff, they must make provision for housing allowance, which is normally pegged at 15% of the basic salary. The other part of the minimum wage is hours of work. An employee can only work up to a maximum of 52 hours a week, which is spread through 6 days of the week. So it starts from Monday all through to Saturday, with Sunday being a rest day. We must have it at the back of our minds that in the event the hours of work go beyond the 52 hours, there is also the risk of payment of overtime for this particular kind of employees who are subject to the minimum wage order. So as you plan out your work schedule for your employee, make sure that the working hours are around 52 hours or less. The third issue, or the third item in the minimum wage order, would be the annual leave. Aside from the routine off days, we do give our gardeners, our house helps, and all those our lovely people who support us in our homestead. We must also ensure that they proceed on annual leave, and under the law, they are entitled to a minimum of 21 days leave. So the way this is structured is that an employee is entitled to 21 leave days all throughout the year. And these leave days are prorated such that as the year goes by, the employee accrues leave on every month of the year. So just like I've said before, there's a very, very clear distinction between annual leave and rest day. Then minimum wage order, as we've indicated earlier, stipulates that an employee works for 52 hours a week, spread throughout the 6 days of the week. You will note that ordinarily a week has 7 days. On the 7th day, the minimum wage order identifies it as a rest day. The rest day should not be construed to amount to annual leave. Annual leave, on the other hand, is taken during the normal working days of the employee, independent of the rest day. So as we work out and we consider how we structure our leave days and our rest days for our employees, let us not confuse the fact that your gardener has gone away on a Sunday, being the 7th day of the week, to mean that they are on annual leave. That cannot be the issue. So to distinguish between annual leave and rest day, we must take note that under the minimum wage order, an employee is entitled to 21 working days leave all throughout the year. And as we are all aware, leave days are prorated, accrued every month as we go through the year. On the other hand, we will equally note that unlike the normal employment contracts, the minimum wage establishes the maximum number of hours an employee, the subject of the minimum wage order, can work. And this, we have said earlier, is a maximum of 52 hours a week spread out through 6 days of the week. So then you will note that obviously a week has 7 days, and having worked for 6 days, there's 1 day that is remaining. This 1 day under the minimum wage order is referred to as the rest day. A rest day is completely and very distinct from annual leave. Whereas a rest day is taken after the employee serving the full 52 hours of the week, leave days are taken from the normal working days of the employee during their term of service. So if an employee were to apply for leave, the leave would be considered within the 6 working days, within the 52 hours of the week. The other item I will talk about is the sick leave. An employee, the subject of a minimum wage order, is entitled to sick leave after 2 months of continuous service with an employer. And after the lapse of these 2 months, the employee will be entitled to 30 days sick leave with full pay, meaning they'll be enjoying all their full benefits as an employee. And upon the lapse of the 30 days sick leave, the period will be halved to 15 days with half pay for a period of 12 months. So once all this period has been maxed out, then the question that begs is what next? Where, for instance, unfortunately, your employee is terminally ill, how do you go about it? So once you have exhausted the cumulative 45 days sick leave period, then the employer can terminate the employment relationship on grounds of ill health on the part of the employee, or we could say incapacitation, because the employee is no longer in a position to discharge the functions for which he was employed. But we must also note that you do not necessarily need to go through this 45 days cumulative. And the reasoning behind this is that this is entirely at the discretion of the employer to make an informed decision whether to immediately terminate the employment engagement without going through the motions as earlier indicated, or taking the employee through the motions that we have just indicated. While exercising this discretion, the employer must be very, very careful and very rational in their decisions, such that any other person faced with a similar scenario would have arrived at a similar decision or conclusion. I think with that, we have clearly set out what are the salient and the bare minimum conditions that we must ensure we comply with when we are dealing with these employees, the subject of minimum wage orders, and generally what is set out in a minimum wage order.
Thank you, Erastus. Quite informative. And, as you were speaking, I was just thinking, given that we are all human, we live with these people in our homes, our drivers, our farm hands. I don't know if any of you have been in a scenario where someone went for Christmas and did not come back.
Indeed, that is a common occurrence, and we have encountered it many a times. Our helps, our assistants in our homes retreat for the December holidays, find greener pastures, and just decide not to come back. And whereas this would amount to absconding of duty on the part of the employee without any lawful justification, which, if you go to under the Employment Act, it could be a ground for summary dismissal. But even as we deal with those instances, we must wrap our minds and never forget that the provisions of the Employment Act still apply to these employees. You must make sure that you've made effort to try and reach this particular employee who has absconded. And if reasonable time has passed, you can then notify them in whichever means you choose to, be it through a call, be it through a text message, be it through an email or a letter, that noting that they were supposed to come back to work on a particular day, and despite various efforts and having failed to return to work, then their employment turns terminated. Only then can you shield yourself from a claim for unfair termination that may be brought by that particular employee. But again, this is entirely case-by-case scenario. There is no clear cut. We cannot preempt how these things are likely to happen. But as and when they happen, you have to exercise discretion on how we handle these issues because they are not clear cut. There's no fixed way on how these things might pop up. But as and when they come, we must exercise proper discretion and be rational in whatever decisions we make, not forgetting the provisions of the law.
Yeah, thank you, Erastus. I was just thinking that, maybe employers do find themselves in this situation because of failure to adhere with the law as you have put it out. But moving on to our next discussion and maybe to close off this issue of minimum wage, during last week's Labor Day, what pronouncements did any of you hear made by the president on this Labor Day? And what do we expect to see this year, 2024, this issue of minimum wage?
Thank you so much for that, Jonathan. Unlike what we have seen in the past, and I think probably because of the fact that there might have been different opinions on the raising or the increase of the minimum wage, what the President of Kenya did on 1st of May during the 59th International Labour Day celebration is that, and I had said this before at the beginning of this discussion, the President directed the Cabinet Secretary in charge of Labour and Social Services to liaise with, first of all, to actually constitute or otherwise put together the members of the Wages Council and then consult with other stakeholders so that they could come up with a percentage. And actually, the President mentioned at least 6% minimum wage increase for the benefit of the employees, and especially the cut of employees that we have spoken about at the beginning of this conversation. Now, I have said that that pronouncement might have been informed by a number of factors, and one of them is, and I think later within that celebration, we saw the COTU Secretary General speak and deplore on the President and the stakeholders really to consider an increase of 22.5% of the minimum wage, which is what he said the workers would have best benefited from. But we've already said the President talked about at least a 6% increase. And then we also saw that earlier this year, 2024, the Private Security Regulatory Authority was pushing for a minimum monthly salary increase of 30,000 by security firms for security guards. But this was way before we even got to May, and that directive was challenged, and we understand that the matter is actively in court. So there's generally the feel on the ground from what we saw from those celebrations is that, yes, there's a need to increase the minimum wage. So my thoughts are that when the President of Kenya made the directive or made the proposal to stakeholders within the labor industry, that's the Cabinet Secretary and all persons involved, to discuss and consider a minimum wage increase of at least 6%, then he was probably thinking about balancing the interests of both the employers and the employees, given the difficult economic times that the country is facing. Maybe a higher percentage of 22.5% as proposed by COTU or anywhere around there would probably have been unsustainable for the employers, but we shall be waiting to see what the final product will be after and pursuant to these negotiations. And as soon as we know, we shall be sure to advise our listeners on the outcome of this.
Following up on what Sandra has stated, and just to conclude this discussion on minimum wage, ideally, these reviews, the annual reviews, have always been done from time immemorial. On the 1st of May of every year, from time immemorial, there has always been the clamor for review upwards of the minimum wages by persons the subject of the minimum wage order. And the proposal by the government to review that upwards by 6% is just in the normal scope of what ordinarily happens. But even as this happens, the government has to balance the interests of the employees and the employers at the same time. Whereas the trade unions would have loved an increment of perhaps 22.5% as had been indicated by the Secretary General of the Central Organization of Trade Unions, KOTU, that has the ripple effect of leading to layoffs in that sector because it might take the minimum wage bill to unsustainable levels by the employers. As we currently speak, general laborer who would be identified as a cleaner, a sweeper, a gardener, a children's ayah, serving in Nairobi, Mombasa, Kisumu, and Nakuru cities is entitled to a minimum wage of 15,201 shillings and 65 cents per month, or 731 shillings and 50 cents daily. So the question I pose to our listeners is, how many of you comply?
Yes, so I just wanted to transition our conversation to our next part, which is on collective bargaining agreements. We are all alive to our doctors through the KMPDU, Kenya Medical Practitioners and Dentists Union, was at a stalemate with the government over their CBA that was signed in 2017. You know, I found it very interesting that the courts pronounced themselves on the nature of CBAs or the intervention of CBAs as between the parties. And the court was of the view that a CBA is a document in evolution as between the parties. And no one party can take a hardline stance, given that it ought to be an agreement between the parties where there's give and take. So I just wanted to lay a basis for us to transition into our next conversation on CBAs, opening it up to our panelists. Maybe you can tell us, what are these CBAs? What is their legal framework and what do they entail?
So, Jonathan, a collective bargaining agreement is basically an agreement between an employees' union and an employer or an employer's organization, crystallizing the terms of engagement that will apply to in the employment relationship between the union members and the employer or the employer's organization.
Yes. So from what I'm gathering is that with regard to these CBAs, there are those employees who may be unionizable and those that are not. So to throw it out to you, how do you breathe life into this CBA? Who are the parties? Are there any fees payable? So I'd like to hear your thoughts on those.
A collective bargaining agreement, first of all, has two main parties to the equation. The first party on the one hand will be the employees' union. So an employees' union is an organization that is crystallized or formed by persons who are employed within a particular sector of employment. So for instance, we all know that we have a union that represents teachers. We have unions that represent doctors. We have those unions that represent security guards and many other trade unions. On the other part of the collective agreement is the employer or the employer's organization. An employer may engage with a trade union either individually or they could come as a group of employers and engage the trade union. On the other hand, also we could have an employer's organization, and one such organization is the Federation of Kenya Employers, which is the main umbrella body for many employers within the country. So having identified those two distinct parties to the collective agreement, let me also just add that in certain instances, we have those collective bargaining agreements that are executed between the various trade unions or a trade union and a particular ministry or department within the national government or the county government. So having said that, the next thing that we will address is the negotiation bit of crystallizing the collective bargaining agreement. So once the parties have agreed that there is need to come up with a collective bargaining agreement, obviously the trade union has its leadership, which is crystallized in its constitution. and the employer will also be required to come up with representatives who will be in a position to negotiate on their behalf and to make decisions that may end up to be binding to the employer in relation to the collective bargaining agreement. So in summary, the trade union will naturally push for a good or a better bargain for its members, while on the part of the employers, they will try as much as possible to push on something that will, on a bargain that will not be very bearing on their financials. So once the parties to the negotiations have crystallized the terms, or otherwise the salient features of the collective bargaining agreement, then they will be required to do two things. A collective bargaining agreement does not just become binding by the fact that the parties have executed it. The document takes effect or draws life and becomes applicable once the same is deposited in court and recorded by the Employment and Labor Relations Court. Ordinarily, and as the practice is, the employees' union, once the collective bargaining agreement has been signed, will file a miscellaneous application before the court and have the collective bargaining agreement adopted as an order of the court. So finally, I'll take you guys to section 59(5) of the Labor Relations Act, which then talks about the effect of registration of a collective bargaining agreement. So then we have just come from the run-up of what happens once the parties have executed and filed a collective bargaining agreement and have had the same adopted as an order of the court. So then what then happens? What is its legal effect? A collective bargaining agreement, once signed and filed in court, becomes enforceable and shall be implemented by the parties to that agreement. It officially becomes a binding contract between the employees union, the employer, or the employer's organization, so that for any party to depart from what has been agreed within that collective bargaining agreement, they'll have to reopen it for discussion or negotiation, as we can see is happening between the Kenya Medical Practitioners and Dentists Union and the government regarding that collective bargaining agreement that was signed in 2017.
As we bring our conversation to a close, I just wanted to briefly highlight how an employee can derive benefit from a CBA. And really, what is at the heart of this CBA is the freedom to associate with that CBA as underpinned in our Constitution, Article 36. Therefore, taking the example of unionizable employees within the banking sector, one may choose to opt into being party to the CBA and another may choose not to. For the one who chooses to do so and derive benefits from the CBA, it is upon registration and deduction of trade union dues that one can derive full benefit. Therefore, in distinction of the two, you may both be unionizable, but the mere fact that you choose not to be part of the trade union within your sector, it may leave you in a circumstance where you actually are worse off than those employees who choose to be party to the CBA. I'll open the floor maybe to my panelists again for any final remarks on this issue.
Thank you very much, Erastus and Jonathan. The very last point that I wanted to make on this discussion on collective bargaining agreements, and which I thought is important to point out, especially for the benefit of employers then, is that in this era of data protection and confidentiality of information, it is important for employers to know that within the law, the Labor Relations Act, they are protected on the information that they share with trade unions for the purposes of negotiation of a collective bargaining agreement in the process of those negotiations, so that such information that is given to the trade union by the employer is then the Act actually mandates it to be carried and treated as confidential. And therefore, any such information that may have been shared by an employer to a trade union for the benefit of the negotiations is not supposed to be disseminated, disclosed, or shared to any other person who was not a party to those negotiations.
Thank you so much. And as we wrap up this conversation, I'd like to thank you all, our very esteemed listeners, for the time you have taken to listen to this podcast. I'd also like to extend my gratitude to my fellow panelists, Sandra, Kavagi, and Jonathan Kisia, for the time. The conversation has been indeed very insightful and very fulfilling, and we hope that you will draw a lot of insight from this conversation. We would be glad to receive your feedback and your views on the conversation. And we also encourage you to listen to our previous podcasts and be on the lookout for our next podcasts, which should be coming out anytime soon. Thank you so much, and
Goodbye.
Goodbye.